Okay, so officially now, hello everyone. Welcome to our first Speculative Legal Theory Network meeting for this year. And here we are honored to have as our special guest for this meeting, Professor Laurent de Sutter, who I'm going to read like a short bio here. Where is it? Laurent de Sutter is professor of legal theory at the Free University of Brussels and the author of more than 20 books, among which Narco-Capitalism, Life in the Age of Anesthesia, After Law, and Deleuze's Philosophy of Law. He has done a keynote speech at the last Critical Legal Conference last year, which had this theme of what uh, is there and what is post-critical legal theory. What does it mean to talk about a post-critical legal theory? And when I found that about that, I thought it was very connected to our interests here because, as some of you know, this idea of speculation, in a way, it is proposed both inside and in contrast to critical legal theory, right? We are, in a way, within the tradition and the world of critical legal theory, and that was also the case in the Critical Legal Conference where Laurent gave this talk. And at the same time, speculation contrasts with critique, and in a way, critique in modern philosophy comes in to take the place of speculation, in a way to close the possibility of speculation. And also, as you probably know, a lot of what we are doing here has to do with bringing into legal theory currents of the contemporary humanities and philosophy that are bringing back speculation in a certain way, establishing a kind of contrast with the dominance of critical philosophy, at least since Kant. So before I pass the mic to Professor Sutter, I just wanted to say, for those of you also who don't already know, that we are really excited that this year's Critical Legal Conference again is going to be themed speculations. This is thanks to a member of our network, Yannick Kahl, who is involved in organizing this instance of the Critical Legal Conference, but I think it also shows some interest and recognition in what we have been doing in terms of this network, in terms of the streams that were proposed connected to speculations, also connected to our work here. I convened a stream about speculative legal theory. Robert Harian, who we are planning to have a session with him soon, also proposed a stream related to speculation. So we really feel like there is a lot going on around this idea of speculative legal theory. We're also talking with a major publishing house about the possibility of doing an edited volume around speculative legal theory, about which we hope to have more news soon. And this is also coming out of an event that we had last year at the Kant Center for Critical Thought. So yeah, hopefully we are going to start having a lot of meetings now moving forward during this year. We're already talking to a lot of interesting guests, but I think that we're starting with a really key figure in this whole scene, who is Laurent de Sutter, who is going to talk about what is post-critical legal thinking, taking on from this speech that he gave last year. And also, as we were talking about possibly moving forward into more speculations about what this post-critical theory might be. So be prepared to enter into a dialogue after this initial presentation by Professor Laurent, because the idea is for all of us to think together about this. We are thinking about this more as a kind of a workshop style thing than a more vertical kind of question and answer. So after the initial presentation, the idea is for us to really engage with trying to think together and trying to come up with concepts of what post-critical and what speculative legal theory are and how they might relate to each other. So without further ado, we already talked a lot. Please welcome Professor Laurent de Sutter. Thanks for coming, Laurent. Thanks for your interest in being here.
Oh, well, thank you very much for the the nice invitation to participate to your discussion. And I'm very impressed by all the things that you're doing and the way precisely you move forward. Me having the tendency of being some kind of a lone wolf, I'm always impressed by people who actually get organized, because that's what, also politically speaking, that we need in the present time. So it's quite remarkable what you've been achieving. So thank you for having me on that. So I understand that this is more of a conversation, and I don't intend to make some kind of formal presentation of what is presentation with with an answer and then arguments backing the answer and so on and so forth, for several reasons. One is, of course, that I don't know what post-critical legal thinking is myself. I don't have any certainty about that, but also because of a question of, I would say, style. And I believe that a question of style, despite what it might seem, is perhaps at the core of what we are doing here, and the type of things that you and I are sharing, namely the fact that there is a style of thinking that I say we feel, but at least I feel has had its time, which is precisely the type of conclusive thinking, so to speak. So the thinking that comes, that express claims and then defends theses, built up on arguments, comes with more or less grounded and solid principles, and so on and so forth, so that at the end you have the inescapable conclusion, like in the Matrix, the moment when Neo is supposed to die because Agent Smith is saying, this is the sound of inevitability. There is no such thing in theory, and I think that if there's something that we have learned from the past decades of theory, is precisely that what we are doing is precisely speculation, in the sense of formulating proposals and not formulating or devising systems or theses and so on and so forth. So everything that I can say about post-criticality is not so much a personal position, it's not so much a theory per se, but a series of explorations or a series of gestures towards precisely the provocation of a conversation. So things that I put on the table, not knowing if they have any sense, but in the hope that someone could grab it and do something with it in some very pragmatic sense of the word. And I think that it is a second, perhaps, key issue when one speaks about criticality. Post-criticality is this pragmatic dimension. How is it present? How is it not? Question of the use, what you do with things, usage, and so on and so forth. So with that kind of precaution put into put forward, perhaps I could start by wondering a little bit about how I came with the idea that perhaps in law, after in other domains, and we know that it started in mostly through the figure of Bruno Latour, but then it somehow migrated towards literary theory. I came to somehow feel that perhaps there was something there in this call for a post-criticality that would meet at least one or two of the most urgent problems of contemporary legal thinking in general, and perhaps of contemporary law also in general, before eventually finishing, because you asked especially for, specifically for that, finishing about a couple of things out of this little booklet that I've written, that unfortunately is not available in English, which is called Magic, which is about obligations, magic, necessity, and contingency. Because indeed there is also something perhaps worth, I don't know.
I was
perhaps
rereading
worth.
it, and I really think that it's a speculative legal theory book for sure, even though the title doesn't even make it clear that it's a legal theory book. But I think it certainly is, among other things, an intervention in legal theory. I think we need to get it translated, really.
Oh, very well. I'd be happy. The title of this book, I will come back to the book, but the title of the book is quite, it's a very banal story. Uh, I tell it anyway. It's 2 minutes lost, but whatever. In France, the cultural and publishing landscape in France is quite singular, with this kind of strong ties between both the press, a certain readership, which is not simply the academic readership, but a kind of general readership, and of course the publishing business. There is an economy that still somehow survives and works. So when you publish a book, even a book about weird, Roman legal categories, you ask yourself the question whether how to sell it or not, because there's the hope that actually you could sell, which is, but the problem is that when you see the word law on a cover, you can divide your sales by 10. It's you take a zero out of your sales, and this is something that publishers, they are frightened about anything concerning law, which says a lot about the current state of our relationship with law. It's the thing that we don't want to know anything about. It's like accountability. There are two things that people hate. It's accountability, the accountancy of business, and law. This is obscure, boring. We don't want to hear anything about that, and it reflects. So eventually they asked me to come up with a title that could be more enticing. So I said, well, why not that? And they were very happy with this. And actually we sold a few thousands, I don't know, I think it was 4,000 copies of this thing, which is basically a book about, which was a talk actually, but about the history of obligation in Roman law and what it tells us about the magical status of law in general. But I will perhaps end up with that. But first, this question of critique and of criticality and the relationship with critical legal studies. To put it in very simple words, there's nothing very sophisticated there. Obviously, the problem, and I think the problem, I suppose, for all of us here, is a problem of power. The problem of power that thinking or thought or ideas or philosophy or theory gives to itself in its relationship with whatever, in relationship with what there is, in relationship with what exists, use the expression that you want, its relationship with the outer world or whatever, The problem of power, a problem of power that can be formulated in very simple terms also, which is the fact that in the history of critique is the history of the development of tools, concept, ideas, that allow those who use them, and preferably those who design them, are always right, are always, can always triumph over those who don't use them. So there's something of a long fight that is the entire history of critique, and that can be extended to the entire history of philosophy, of knowing who is going to get the strongest argument, the strongest truth, the most powerful idea, and so on and so forth. There's, let's say, a gigantomachy of power at work within, let's say, the Western philosophical tradition that has been systematized from the 18th century onwards within the critical apparatus, through, of course, the genius and fantastic gesture put forth by Immanuel Kant when he decided that every category of thought actually should be justified from within thought itself. So the question of the force becomes the question of how, let's say, concepts based on their own pre-assumptions, so to speak, produce their own effect of force on the other concept that they can meet. And of course, this question of force, that's why perhaps it has striking a particular chord with me. They are formulated, especially in Kant, but when you read, let's say, the totality of the critical tradition up to the present day, it has been formulated from the onset in legal terms. So the question of how you create a system of thought that gives you the power to force the truth to appear, to force truth to appear within the world, is predicated upon a series of references, categories, ideas, reflections that are all extracted from the legal world, in such a way that I can give you an, just open, open again, the critique of pure reason, and the only one thing that you will see is trials, inquirers, judges, advocates, police forces, of course, rules, principles, judgments, the totality, let's say, of the apparatus that makes it move outside, let's say, of the architectonic, of the schematism of critique. The flesh, let's say, of the schematism of critique is a juridical flesh. It's not very original to say so. Even someone as not radical as Hannah Arendt, outlined it and said it in her lectures on on judgment and on the faculty of judgment in Kant. So there's something there which is strange for someone who has been educated like I was in critical legal thinking as the thing that emancipates us from forms of power that exist in society, especially political and economical forms of power, through the use of certain tools that are deemed by principle, because they give us this power to, let's say, dispel the illusions of the social world, give us the power to actually, expose the truth of it. There's something weird in that, and something almost dismayal, when as a lawyer, you realize that the thing that you think you get rid of, well, precisely, catches up with you on the other side of the pipe in some kind of almost circular move. And this circular move, where law becomes the force that allows you to negate your own engagement with law, so to speak, that gives you the ground to say the truth about law as a horrible truth, of course, because the presupposition is that the truth is always, horrible, morbid, disgusting, shit. Literally behind what there's always a shitty truth that that is to be found. And it's quite funny that this shit that we are going to find inside of law is law itself as the thing that allows us to see the shit in law. So this kind of buckle, this kind of short circuit of critique has started to bother me, starting, of course, with the meeting. It's a story that I've already told. I'm sorry if I repeat myself here, but with the meeting that I had in the early North with Bruno Latour and Isabelle Stengers, when I did my, my PhD, blah, 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 with them. And it was a moment when precisely Bruno published this ill-famous, the ill-famed article, Why Has Critique Run Out of Steam, where he tries an attack Jean Baudrillard and others, and he's a bit hysterical about what's happening in humanities. And the article is very bad, but there is obviously this central argument, which is quite strong, is the fact that, whether you look at things from the point of view of facts, or when you look at things from the point of view of beliefs, you always win your case, because when you look at a fact with a critical eye, you will also see the truth of this fact under the guise of beliefs of those who claim that there is a fact. And when you look at beliefs, you will always see the sad and ugly truth of the beliefs of people. You believe in God, you believe in freedom, you believe in whatever, through a series of facts actually determining this belief. And the fact that with critical tools, you always look from the other side in order to ruin, let's say, the thing that you're considering. For Bruno, it was obviously a scandal, because there, the procedure that was at stake with it was a procedure that basically was a procedure of negation. So what you would see would always be something of which you had to retract something in order to get to what would be the actual truth of this thing. And the actual truth of this thing, again, would be, this little machine, this little horror that you are, or you supposedly are, the only one to see. So there is this logic of striptease, if you'd like, at stake with critique. The critique is the one that, you take the clothes and then you expect to get to the thing, the nakedness of the thing once you unveiled all the layers of illusions and so on and so forth. And Bruno, obviously, for him, it was nonsense. It was nonsense because what he has studied through, his work on laboratory life, science, Pasteur, all these things, and even law. At that time, he had published his book, The Making of Law, which is an amazing book. Lots of problems, also amazing book. What he had come to realize is that actually a thing is a thing. Whatever you can call a thing, and whatever your theory of a thing is, but a thing is a thing only through the innumerable layers of things that you've added to nothing, And the movement, obviously, is a movement which is absolutely the reverse of what the critical move is, the kind of striptease, getting to the nakedness of things through and reach the obscene object at the core of what exists, is something that actually doesn't tell us anything except the power of the one who sees it. Whereas when you have to redescript, reformulate the amount of layers that you need in order to get to not so much of a definition, but something like the possibility to grasp the existence of something, then it requires from you tools that are absolutely different than that, absolutely different than all these super powerful arguments, ideas, concepts through which you are going to to clean the table and reach this moment of nakedness. And for me, it was kind of eureka moment, and the eureka moment that went that was contemporary in my own self-education as a lawyer who was not happy with what I was taught in law school at the time, with the work of a French legal historian, unfortunately not very well known in the Anglo-Saxon world, even though there is now a collection of his essays published in English. This French historian, Yann Thomas, a guy who died, unfortunately, quite young. He was a very close friend of George Agamben, lots of people. And he had this, specialist in, Roman law and to a certain extent medieval law. And the guy had published these articles throughout his career that were just crazy genius, literally, technically speaking, historically speaking, but also speculatively speaking, so to speak, because it would reinstate within law the thing that precisely the critical gaze would try to get us rid of, namely what actually law does. Law does not in the sense of, it oppresses people. We know that, thank you. It helps in reinforcing capitalism. Yes, sure, we know that as well, and so on and so forth. But what law does in such a way that, for instance, it could enforce capitalism, patriarchat, colonialism, and all the usual suspects. So what is exactly that law does, and what in law actually does things? And for me, it was the second eureka moment. And from then on, I've tried to somehow, bricolage what I would call a theory of legal operation, not legal, precisely not legal, of juridical operations, that for me is the way to try and deal with the possibility to open up a post-critical gaze, or to open up a post-critical path in legal analysis, not only legal theory, but also even in legal doctrine to some extent, without necessarily throwing the totality of the critical, legacy with it. Because I've been, very fast, obviously, very caricatural, but that's where I come. You don't negate yourself that easily, and still the question of critique, because of the positions and the points of view and the perspectives that it opens, it remains an essential tool for all of us. As there are things everywhere that we use and that we need, and so on and so forth. But in terms of how do we do now that we are put in a situation where actually this power of critique has become has become something different than the monopoly of those who actually design these concepts, but actually has become what I would call the default setting of contemporary thought. Critique, the critical program, let's say its problem is that its relationship to power has democratized to a point where it is now literally the default setting of anybody's system of thought, not only the academic, not only lawyers, but literally anybody. There is nothing more critical in the intellectual sense of the word than someone who would vote for Trump. They're the very embodiment, or someone who claims that the Earth is flat. They are using all the sophistication of all the sophistication of the critical tradition through the force of this and the power of this tradition, in order to indeed see the truth that they want to see in the world, the ugly truth that there is, that Joe Biden is a pedophile doing obscure things underneath a pizzeria in Washington. This is precisely, let's say, the type of result that we can produce with critique, because critique is not about being proven wrong. It's not about respecting in any way what you meet. It's about saying in what you meet what this thing hides. So if indeed I may be wrong, again, it's things that are thrown there, right? Can trash them, eat them, shit on it. I don't, no matter, no problem. So the problem, if there is one, with this generalization, with a triumph, the absolute triumph of the critical program these days, is that obviously it obfuscates and it renders very difficult to reformulate perspectives of emancipation or progress in a way that is meaningful, because precisely it is so entrenched and so strongly related to the history of critique, that we have the feeling that if we get rid of critique, then we are going to get rid also of our fight against capitalism, patriarchy, and the like, as if these things were one and the same, as being a leftist lawyer, so to speak, was the same as being a critical lawyer. And if you're not critical, then it's impossible to be leftist, and the other way around. So for me, it was important to try and do something with this conundrum, because the only thing that we see now with our attempts as lawyers to keep the critical flame alive is basically sad. It's attempt at, I don't want to be mean, but when you go to critical legal conference, half the sessions are about, Zizek's reply to Badiou's reading of Louis Althusser's interpretation of this very specific period of Marx, and perhaps in this footnote he was wrong. That's basically the level of sophistication that we have reached, pure scholasticism, right? When the critical apparatus looks at itself and its, underbelly and so on. So there's a tragedy at stake, so to speak, with critique this day, and how to make it so that the emancipatory dimension, the emancipatory ideas or perspective that was at stake at the beginning, and that indeed produced effects of emancipation at some point, how do we make so that this thing can be somehow made more or less active and not reactive anymore? It's still there. And that's why I with Latour on the one hand and Thomas on the other, I jumped on this idea of operations. It may sound, again, something quite banal, but it's an idea that, well, the basic intuition here is to say that perhaps the problem with law in this circularity of the criticality towards law, the fact that critical legal studies look at law as this thing that has a problem, but do so with the tools that themselves are predicated upon a specific legal history, namely the history of judgment, the history of the trial, how a trial works, how the trial goes back to an understanding of the world based on principles, arche in Greek, how it's predicated upon a form of trial, which is absolutely Greek, the moment when the Greeks themselves, made this kind of jump between forms of trials where people would simply solve their case together, to the moment when there was this, the starting of this triangle, crisis, when the word crisis, which means judgment in Greek, as you know, will appear in ancient Greek. It was precisely in order to designate this change, this shift in the form of judgment from the ancient form of judgment, kind of where kind of, you know, between parties, so to speak, and suddenly the judge himself being allowed to intervene out of his own positioning and out of his own supposed access to a certain idea of the rule and the ought to be and how the society should work, and then be able to impose a division of the situation. Crisis is also to divide, that could distribute the good and the bad points, you know, between people. So how do we deal with that, you know? And the only solution that I've found through the study of certain operations, including the operation of obligation, of which I speak in this little booklet, is precisely that, is the fact that perhaps, but again, it's also speculative, perhaps, you know, perhaps always a matter of speculation, is was if, you know, kind of fabulation, speculative fabulation, a story that we need to tell in order perhaps to displace a point of reality, right? It's kind of a narrative that's at stake there, which could become a performance, and a performance that could become transformative. So what if, contrary to what we still believe as critical lawyers, law has had and still has nothing to do with normativity? What if law had nothing to do with the deontic, with the ought to be? What if law was something else than that? So not something that would be there to say, you have to do that, it's prohibited for you to do that, or somehow, you know, okay, you're allowed to do that, right? Not about the policing of behaviors or bodies, not about institutions and the guarantee of institutions. So not about adjudication, not about legislation, not about government, not about, you know, executive power, but are something at the same time more modest, much more modest, but also much more decisive, especially from a speculative point of view. And that would be the operation. Of course, in English, it's very hard to describe. I will give a few details about, you know, on that in a minute, and then I will stop. But it's very hard to tell. It's a story that is hard to tell in English, because English is the only Indo-European language that doesn't have the distinction that other Indo-European languages have between the, let's say, the objective sense of law and the subjective and the objective sense of law, so to speak, as a thing, and the normative sense of law as precisely the thing that is in charge of normativity, of ought to be, right? So when you see droit, loi, Rechtsgesetz, Recht, Wet, diritto, legge, derecho, and so on and so forth, there's this kind of distinction. There's always a sense in which law means something else than the rules or the rights. In English, it's complicated because law encompasses, in a strange way, the dimension of the normative and the rights as part of the normative. But when people do a distinction in English, they make the distinction between law and right as if rights were different from law. It's not true. You know, rights are part of the law as the subjective dimension of the thing that is, you know, made possible for a subject to act, to do or not to do according to rules, right? When I speak about operations, I speak about something very different, of which the Romans were very attentive, because that's what they invented. They didn't invent, they didn't create, you know, the gun on your head and now do it, otherwise you are going to get, you know, spanked. That's not what they invented. You know, this has been part of the story since whenever, right? What they invented was something very different. It was something about, in a given situation, whatever it can be, the situation can be, you know, two people wanting to do something together, you know, and want to know how to tie their relationship in a way that makes this relationship more substantial than simply saying, okay, I promise you something. Okay, I will do. Yeah, I promise you something also. I will do it. And that's the end of it. They were intrigued and they were interested in building tools in order to make so that these relationships between humans and non-humans, between forms of non-humans themselves, between abstractions and realities, between all sorts of beings, they wanted to create some kind of bonds, but bonds not made out of necessity, not bonds made out of you have to, but bonds that could produce effects by their mere formulation or existence. formulation does not mean here performance, like in speech act theory, when you say something and then you do it, No, it's something much more, let's say, pragmatic again here. And the operations of law, these operations that are still part, whether we like it or not, and to some extent, of course, we are right in not liking them to a certain extent, but all these operations are still form the basics of our contemporary legal systems. Okay, obligation is one, qualification might be another, marriage, affiliation, and the list is endless of things that had never been devised, created, formulated by any form of power whatsoever. There was no, judge who suddenly came up with the idea of marriage. There was no executive power that decided at some point there must be contracts. There has never been a legislator deciding about what is the relationship between parents and children. There has been carefully crafted operations by these weird guys who had nothing better to do in order to build up a form of necessity out of the complete contingency of given situations. Of course, this necessity, it's hard to ground. How do you ground necessity out of the contingency of everything, right? We know, especially us, after Kant that the only necessity that exists is the necessity of the absence of necessity. The only absolute is the absolute of the contingency of everything. So how do you make so? They were very well aware of that too. And that's where perhaps the analysis of magic can bring us a few interesting, lights, in this, how the Romans did build operations of law outside of the realm of normativity that allows necessity to flourish out of the contingent. Magic, but not any form of magic, not the, Harry Potter magic, not, Merlin magic, but the magic that was analyzed by this generation of anthropologists at the end of the 19th century and beginning of the 20th century. They were very interested in magic. Nowadays, anthropologists are not that much interested in magic anymore, or the category of magic as such, but there was this moment at the end of the 19th century, beginning of the 20th century, with people like, Fraser, Codrington, and others, who looked at magic in other, communities, non-Western communities, primitive, they would say at the time, communities, right? And I would say forms of action, forms of relationships, and forms of consequences that were based on things that were inexplicable by the usual social instances, social pressure, perhaps subconscious, I would say manipulation, but subconscious determination, power structure, so things that had nothing to do with all that, but that still performed, or that still realized, or that still achieved some form of effects. And quite interestingly, one of those who went perhaps the further in this direction is Marcel Mauss, who is in his general theory of magic, looked precisely at law as this thing that was the closest that he could think of to magic, because with law, and especially with Roman law, but what we could see at work is the art of the reversal of causes. In our tradition, let's say the Greek, let's say, philosophical tradition, up to the critical tradition, causes work, first, and consequences come afterwards. What Mauss observed is situations where actually it was the opposite. It was the consequences themselves that caused the causes that caused themselves. In some kind of a retroactive movement, when the necessity of things didn't come from the soundness of a principle, or the soundness, or the strength of ground, or the power of something you already have, but the soundness of things, or the necessity of things, comes from basically doing it. It's very Jamesian, avant la lettre, if you'd like. A very William James way of presenting things. And indeed, the nice thing about legal operations in Roman law, is that this is precisely how they worked. They worked as consequences building up their own necessity. Of course, you can say, okay, yeah, that's easy, right? You do something, then you look backwards and, oh, that's fine. We have now a necessity because it exists. It's more complex than that, actually, because what the consequence is when you invent obligation, you create an obligation, you create a system in which when someone does something, the other has to do something different. And then somehow it balances itself altogether. What's the interest of it? And the interest of it is, of course, that the contract is fulfilled somehow. But its fulfillment is not the end of the story. Its fulfillment is what allows another consequence to appear. For instance, another contract. Or in the contrary, if it's not fulfilled, it could lead to another consequence, which is, well, your own status as a being has changed. You have breached a contract, so now you're a thief, or you're someone who has has committed a dull or whatever lesion or whatever they could think of at the time. So it creates a consequence that reflects upon you, which becomes an ontological consequence, which in itself has, thanks to other operations, other consequences. So the question of the consequence for the Romans, and in magic too, is never the question of one consequence becomes necessary because there is one cause, but one consequence becomes necessary because there's another consequence to the consequence. So it means that legal operations, as I understand it, are always speculative questions about what are you going to do next, or what is possible next. If you're married, then it's possible for you to have that, it creates consequence in terms of filiation. If there are consequences in terms of filiation, then there are consequences in terms of patrimonial transmission. And then if there are consequences in terms of patrimonial transmission, and so on and so forth. And what they did, if you look at the history of Roman law, is precisely this kind of tree of operations giving birth to other operations, giving birth to other operations to the infinite. And that's the great thing about the whole story, is that every set of operation opens up a possibility for another operation. And indeed, they invented crazy things. You know that, as well as myself, all the fictions they came up with, all the presumptions they came up with, all the machineries that they created, even created a world of science fiction, a world where we are surrounded by dead people doing things, by abstractions, creatures living in, I don't know which space, enterprises, state, and they are part of our lives as if it was, this table or our friend, our best friend. They are as mundane, as consequential, as necessary to our lives as the most material things that we can think of. That is, for me, the speculative legacy of Roman law, and the fact that they are centered on operations that are not so much concerned about what you have to do. Simply, if you do something, then something. It's very different than you have to do or, and if you do, then it's absolutely, obviously, it's absolutely not the same rationality that is at stake there. It means that when you look at law from an emancipatory point of view, it is, I wouldn't say useless, but it has become a little bit desperate to try and crush the legal machinery under its own impotences, violences, and so on and so forth, if you do not consider that within the machinery itself, there is something that always makes the machinery fail, because there's always the possibility untapped within the scheme of operations and within a certain state of operations, within a certain architecture of operation that we can criticize if we want. But it's never finished. And this is the, for me, this is the lesson to perhaps to meditate when we speak about law. Is it possible to think about the magic, let's say, of law in terms of what are the possibilities that we can invent, technically or otherwise, that could perhaps reconcile us with the ideals of the critical tradition without falling back again into pitfalls of its self, let's say, devouring movement, its self-ruining, melancholy state. And yeah, I think that's basically, I don't know if the point is more or less clear, but that's basically, and I don't know if it is what you wanted to hear. I can go into more details, but basically that's the operations outside of norms. And it's again just that it is absolutely tied to the idea of speculation, of course, because it means that when you're confronted to law, it's always about, okay, what if suddenly, we could decide what are the conditions, and what can we think and elaborate in order to make so that, I don't know, for instance, the planet becomes something that can intervene in the public debate, or what can we invent in such a way that actually the consequences of capital could be avoided for some people, and so that basically that's called social security law in a way, but and so on and so forth. So the question of what if, which is for me the speculative question, because I have this Stengersian understanding of speculation, of course, this what if question, as opposed to the and so, or the how do you translate that, the et alors, the et alors, whatever. I think it's the move that I'm trying to suggest when we in this kind of look at legal operations. Yeah. So thanks for your patience and for listening this wandering.
Thanks so much, Laurent, for your presentation. I'm going to now ask people if, like, maybe we can use the raise hand thing. I started clapping here. I can't make the clapping stop. Yeah, like it's on the reactions thing. So just we can have like the order of people who want to participate. You can either ask questions or just, make an intervention that can then go on, like people can talk in any direction, respond to each other as well. But perhaps if no one has a question immediately, one thing that I think might be interesting to start with is that I get the impression, correct me if it's not precisely that, but that in a way you're referring to a process through which there seems to have been moments or epochs or times when the activity of jurists or of legal how do you say, people who do legal doctrine, was a productive metaphysical ontological activity where you would create these modes of existence almost out of nothing, and this is the magical thing, right? And this is like mixed up with magic in a very concrete and anthropological sense at the time, but where you would make those concepts. And I think you say at some point of the magic book that these obligations are things in themselves, that they are a thing. They are not just a relation between things. They are a thing that establishes these kinds of relations, and you can make those things, right? And or at certain points, people who were creating the categories of law were making those magical things. And then for some reason, and I wanted to ask if you think there's something that can be said about what kind of process is that, what kind of reason is that, things would get more frozen and more calcified, and then we are still using to this day those same things. They are still operating. I mean, they have, of course, gone through some kind of slight changes, and you could do the genealogy of how they change across time, but it does feel like there is some kind of closing. And then one thing that interests us here a lot also is, and I think your presentation connects those things in an interesting way, is the relation between speculation in this very philosophical abstract sense and the relation and speculation in the more everyday sense of speculative legal theory, in contrast to critique, having to do with not necessarily spending your time criticizing the way the law is now, but rather thinking about what else law could be. And this has to do maybe with the contingency of a certain necessity and the possibility of another necessity, right? Of producing entirely different concepts that maybe won't have to do with norms, won't have to do with, but that would still be a variant of what law can be. So we think about that in the context of radical transformations in the conditions of law and of society, such as the transformations of the technological infrastructures that implement law, or the transformations of the ecological infrastructures of the whole possibility of life as we know it on Earth. And maybe then my question in that sense would be, if you think those kinds of transformations may enable new moments in which the possibility of creating new legal concepts would be either possible or at least urgent, you know, because I feel like one thing that we are trying to think about is how can we create new legal concepts that are more adequate to dealing with these kinds of problems, which are not necessarily the same kinds of problems that we had when we created our last bunch of concepts that we are still using, right?
Yeah, true. Yeah, true. Well, I don't know. Again, it's only things that but I've vague ideas about that. First, I don't think that it has stopped at all. Simply, I believe that actually it has been appropriated by some class of lawyers, this capacity to fabricate possibilities, and these are not our friends. And I think that is the great merit of Katharina Pistor's book, to show where things are happening now in terms of legal creation. And it's not, in government, or it's not in, but it's these big law firms who are actually reshaping the very structure of our normative framework through a virtuoso use of legal operations. So these it still happens, so it's still happening, so to speak. But you're right in pointing out the fact that there's some kind of some perhaps epochal move, or some kind of stratification or sedimentation that has been happening. And there, my hypothesis would be, it's a mean hypothesis. It's an hypothesis which is purely gratuitous, but I believe that there are traces and there are texts that could allow to formulate such an hypothesis. I believe that actually it has happened because a Greek understanding of law has supplanted the Roman understanding of law. And this Greek understanding of law has been called for by some lawyers already in Rome, and as early as the 2nd century of the present era. There is basically what Cicero wanted when he said that we need to stop with these lawyer shit, right? And put order into that. And the only way to put order into that would be to set up a set of big principles, natural law, blah, blah, blah. And these principles should be formulated, and Cicero himself said that, in the terms of what the Greek called nomos. That's a quote, that's the exact quote in the De Legibus dialogue of Cicero. He quotes the Greek. And indeed, when you read, historians of ancient Greek law, you can see that. You can see this weird moment when in 5th century BC, in Athens, a choice was made to orient the normative framework of the city in a direction which, let's say, poses or puts the city as a whole as the thing that will structure all the relationships within it in a totality that will define then the existence of what is part of it. It means that then the operations, if they exist, can have meaning and extension only within the general framework, let's say the general design of what is the order of the city. That is the order in the strictest sense of what an order is, namely putting things at its place, right? And Cicero, that's what he wanted, to put order back into the anarchy of law, because that's the nice thing of operations, because the possibilities are always there. It's always about chaos. It's never about order. If whatever you do, there still is this possibility that you haven't seen whatever you want. You can jump on your head. You can do whatever. You cannot eliminate this possibility. That's the definition of chaos. The possibility en plus, the extra, the excess possibility. And so the narrative of law is this thing that can exist only within an order is, of course, the foreclusion, to speak in psychoanalytical terms, of the excess of possibility. And this was, then you can try a sociological, psychological, perhaps interpretation, but it was attractive for people who, they were, close to power. And we've seen that there are fantastic histories of the conflicts, between, for instance, philosophers and jurists at the end of the Middle Age and during the Renaissance, and how lawyers tried to impose themselves as the counselors of the prince, as those who will whisper in the ear of the king and say what the reality is. And of course, if they have this story that they are the holder, the ones who can defend the narrative of the totality, the narrative of order, and that their discipline is the discipline that materializes this order, of course, they have a definition of reality that is also attractive for power. And that's why, for me, if the slowing down of invention in terms of law started in the second century of the present era, and then there were strong hits at the time of the Renaissance. The humanist movement was a huge blow for legal invention, contrary to what we might imagine. We could think that humanists, their big principles, we out of the dark ages, blah, blah, blah. It's probably the opposite, right? Especially, and also in terms of speculative philosophy, medieval speculation, we can discuss about it. And then the last blow is, of course, the 18th century triumph of the liberal tradition. The narrative then was complete. And it's hard, to say that, okay, we have to just put that aside in order to find back this small living things that is the machinery of operation that still, is part of the whole narrative. So that would be double explanation that I would suggest. Don't know if it makes sense.
Yeah, thanks. We have Philippe. I think it's the order. Please tell me if I'm getting the order wrong. And also, I think that Swasti had raised her hand. I don't know if you don't want to ask any more, or if it was because maybe you lost your connection. I don't know what the order is. Like, who is next?
No. I think it's Felipe, and then let Felipe go, and then I can go. Yeah, that's fine. Thanks.
Okay.
My internet is strange.
Swasti, if you're sure. Thank you. Hi, thanks very much for the talk. I read your book, The Magic. I really enjoyed it. And I'm living in Brussels now, so I've actually been meaning to kind of reach out to you, and also to Ze. Anyway, I had lots of questions, but I wanted to pick up on some of the things that you've said, thinking about the question of technology in law, and whether, because I don't know a lot about the the history of law early, and I wondered if the transition from a kind of oral spoken law to a written law, which is a technological step that I don't think is usually analyzed as a technological step, whether that's an important legal operation in the sense that you've been referring to of operations. Because, yeah.
Oh, yeah. That's a good one. No, thanks. Yeah, we can meet. I'm whenever. It's a good question. One thing that I blame myself for is that I don't know Cornelia Wiesmann's work well enough. I should investigate, because this, the media dimension of law is something that is indeed fascinating, and I don't know much about it. What I would say, though, is that this technological move, I don't think, I might be wrong, but at least for Roman law, I don't think that it was decisive. I don't think that it was decisive in terms of exploring the realm of possibility of law. It was decisive in political terms. And that's why it was required, and we know the story, putting laws in written so that it can be publicized and then stop being secret, and things that pontiffs themselves would keep for themselves, and you never know what to expect, and so on and so forth. So it's the beginning, let's say, of a narrative about law uncertainty that then will irrigate, let's say, the legal world in faster and faster, just has to become some kind of a fetish, still our fetish, legal certainty, legal security. We need that, otherwise the world would crumble on its base if we don't have it. And the putting into writing of rules and regulations, and they were not exactly rules and regulations, by the way. It's interesting. I don't know. I'm just trying things there, no, because as a matter of fact, the first, actually the Law of the 12 Tables, all the Babylonian, Mesopotamian writings, they were all prophetic texts. They were not rules. They were the embodiment of a moment when they still believed that there was a connection between the enunciation of something belonging to law and some kind of an effect. And the first writings were actually memories of these performances. At some point, me, Hammurabi, have decided that it's not for people to repeat that, but simply to say that I was great because I managed to create this kind of relationship between I don't know, the farmer and his cow and so on. And it's a little bit the same at the moment of the Law of the 12 Tables. Actually, the forms, the few texts that are part of the Law of the 12 Tables, so the first written text in Roman law, are actually also prophetic texts in their structure, with the protasis, the if you do that, then this will happen, and not a condition. It's not, it's this might happen, this will happen, absolutely necessarily, so to speak. They're formulated somehow at the future and not simply at the and not as some kind of norm to observe and to I should think about that. I should think about that.
I'm thinking that there's always going to be like the social tensions that we see today about who writes the law. Those would also have been present then, right? Even if it's enunciated as a prophetic text or written as a prophetic text, the underlying tensions would likely have been there in the Neolithic tribal society structure, right?
Yeah, sure. But that's what they wanted. That's what actually people asked for it. They say, no, now you give us your rules or we are going to do something, right? Yeah, that's true. That's true. So it's always an illustration of tension, and tension that were mostly based on, it was the case in Rome, and to some extent was the case in Greek. It was always a matter of debt. And what debt do to people. So you're indebted. So it means that at some point you have to, your property have to be, the properties have to be taken away. And if you have nothing to, to take you from, then yourself, you become a slave. And at some point it became unbearable. And there is this repetitive moment in the antiquity where is attempt at reshuffling things and redistributing land and so on and so forth, avoiding debts and so on. And the moments when the publications appear are always moments of crisis like that. So if what you're hinting is that today there is a change in the writing of law, for instance, through, I don't know, software, perhaps it's the answer of a crisis also. That would be nice to analyze, which kind of crisis it is. Perhaps the crisis of the capital structure of normativity, and then the advent of something else, and perhaps worse, if I may quote Mackenzie Walk. In that respect, I don't know.
Yeah, I mean, so the concept of the operations reminds me of the legal primitives, and because I think Maria Hildebrand has also written a bit about the impact of this sort of code-driven and data-driven law. Impact is basically a new way of making law, and so I think it's very similar to what you just said.
Yeah, I was just going to bring up Mireille Hildebrand, who is also in Brussels and works with this idea of modes of existence of law being somehow essentially connected to the technologies on which law is implemented. And then the way that she talks about these two transitions, the transition from text-driven law to code-driven and data-driven law, it can also bring back, for example, like data-driven law has this, and this is a critique that she does in relation to it, that it is about predicting what is going to happen rather than what law should be. And then there is this kind of protective attitude about thinking that, you know, rights and the rule of law and everything supposedly good that we see about law as we know it today is at risk. But at the same time, I think there should be, and this is the point that I made when I was in Brussels with, because I was linked to her project there, and we did a session where I was precisely trying to make the point that we should also think about the creative and positive possibilities of these new modes of existence of law based on different technologies. I think it has a lot of connection with what you brought up. Is it Swasti now?
I can go. So there's lots, Lauren. This is amazing. I really enjoyed myself and it's gotten me thinking about a lot of things. So you'll have to pardon my ignorance and naivety when I ask you this, but I want to come back to the question of, or to think with the emancipatory potential of law and the way you linked it with the side of speculation within that, or what is the role of that. I've been trying to work on speculative law, on what constitutes speculative law, but still stuck with dilemmas of temporality, particularly dilemmas of history, that puts into contest the boundaries of what is emancipation, right? And it's contestable, and it sort of, so when you give that example of law peeking through, or of what is critique, isn't, when we do speculative thinking, doesn't that disrupt that kind of let's say showing through, right? Like the place of speculation can, in other words, okay, I think I've got this. In other words, do you think speculative tools have something to say about the history? I mean, and I'm taking this from Mayor Sue's work, and I'm taking this from, because when we think about the emancipation or the emancipatory potential of law, we often have to confront temporality in very particular ways, of the text, of the practice, of the form. How does speculation or speculative configures in this thing? I guess the other question, or the other way of asking this, would have been, okay, so what is the value of concepts such as spatiality, materiality, temporality, in this thing of emancipation? And I can keep coming back to emancipatory potential because I've heard this after a very long time, which is strange given what the critique is, but also because when we are, and I come from a material law and materiality and spatiality context, one is often trying to slow down the pace of law, right? Like figure out where the law is. Law is everywhere. Taking it from Andreas's work, if law is, then how do you map it? How do you feel it? What is the role of the sensorial? What is the role of the aesthetic? What is the role of the affective? So in the material, spatial, temporal zone, law seems to find itself expressed, and it's sui generis, like, it generates itself because of these encounters. So I'm just thinking alongside with you about this in that sense. Then is there anything to post, like what would be the emancipatory potential of law from that perspective of always being entangled with it, which does not make that distinction between normative and the legal? If there is such a distinction, then obviously there is a distinction of institutional and people, a form, and this particular thinking. Does that make sense? Because I just had these thoughts, and I have to read your book on magic, which Magic is very, I really, the third thing that I want to say was that the whole, the use of the word magic is very interesting when we consider some of the contemporary writings on indigenous knowledges around law, where magic, I know of some examples from the subcontinent where the use of magic or the use is actually to obfuscate the conditions of what is human existence. So it's almost like a ghostly revival of or a spectral imagination of the law, right? So but yeah, that is not a question. That was just me thinking with you. So yeah, I don't know if that makes sense. Thanks.
Yeah, well, it definitely does. I mean, there's so many things that you've said that would be nice to comment upon. I don't know what I would I could start with without entering into another long, convoluted monologue, of which I have the specialty. The thing is, let's start with that. I mean, I would like to start again by emphasizing this, normative, non-normative, normative or operational. Let's say the legal and the juridical as something which is perhaps a distinction of the mind, but I think that this distinction reflects somehow into, as they said, it's in the existence of very specific things. I mean, eventually it adds realities to reality, so to speak. So, and perhaps that's part of the speculative move. But it's important to keep that distinction. For me, it is important, whatever we can say about this distinction, it's important to keep it active as a dissolving agent, precisely in order to be able to ask again this question of, okay, law is everywhere, but what is everywhere actually? It's normativity that is everywhere. It permeates. Andreas works around normativity, and he has a problem with normativity, and I understand that. But he works about that. He's not that much interested in the reconstruction of possibilities through legal operations. It's not his stuff. And I think that we need both. Obviously, we need both. We need this analysis of the forms of existence of law as this thing that metamorphoses into bricks and mortar and flesh and bones and speeches and lights and so on and so forth, on the one hand, so that we can give the biggest possible picture of what normativity is on the one hand, and on the other hand, technique or legal operationalism as juridical operations as this thing that breaks with that order of normativity all the time, because it always involves the thing that is not part of this omnipresence. The fact that there is some kind of almost some kind of a run, a chase between the two, but actually the operations are always first, they're faster, so to speak. Even if we don't see their efficiency, if I don't see what they do, or if we don't seem to invent anything, but at least speculatively again, they're advanced, they run faster. And perhaps that, speaking about emancipation, is precisely putting the accent on the X of emancipation, the outside of, the thing that emancipation, that historically speaking, to be emancipated is to be freed from slavery 3 times by your father, and then suddenly you become emancipated. So you are taken out of the hand, and the hand is normativity. And X out of the hand, suddenly there's something else than the hand that is at hand, so to speak. And I suppose that the operations always point towards this X as a possibility. So emancipation is not so much a program, is not so much a series of things that you have to fulfill so that we are emancipated, but it's this movement, let's say, this presence of, or the possibility of the presence of the outside inside. That is the thing that you are to, that is a question addressed to us as something we can do something with it. Because it's either, okay, it's so everywhere that we can't do anything, then it means that order has triumphed, or there always is this possibility, and then there is something else than order, and then we can speak about operations. But in my view, at least, it's do what you want, with that. It's not about again, Pistor, the bastards know what they want to do with it, and they do it very well. So they invent their own form of emancipation. Is that the form of emancipation we want? But they invent it, they apply it through the use of a certain of these tools, because they have understood where the real shit is, where the deal is, and perhaps if there are things that we care about, well, perhaps then our turn to try and build up things in whatever direction possible. And that's why I do not agree with Mireille. I've known Mireille for more than 20 years now, and we always disagree. But I don't think that her liberal rule of law take on things will help. Actually, it's part of the problem. So we need more than that. I don't know if these are absolutely not sufficient answer to all the questions that you end up.
I mean, my questions were very vague. I really think that is it's that impulse of emancipation, or so what is critique? If the value of critique is configured in the value of emancipation, or in the strive for emancipation, then what kind of tool is speculative thought, or what is it that it enables? And I think that is and in that, then the question is the question that you just answered, which was what is law, and I think that helps to map out that point of conversions. I think it's not so much, there's no answer to this. This is thinking along, I think. Yeah.
So if I just may add just a very short thing, if I had to formulate that in some kind of a small, compact way, I would say that the problem with how emancipation is linked to critique these days, again, historically speaking, is that it's only the emancipation of critique itself that is at stake. Whereas I believe that speculation, if that's something to offer, is always the emancipation of something else. Yes. So the movement is, the folding in of critique requires now folding out, and I think that speculation is this folding out.
Thanks. Yeah.
So Paula, speaking from Bogota, I think.
No, from Spain.
From Spain, cool. Okay.
When my outfit is like kind of pajamas, because here it's already night. So yeah, sorry for that. Professor, thank you very much for your words. I'm kind of flirting with some ideas that appear through your talk and through the questions that the rest of the people asked, but I was thinking exactly about the temporality of law and its relationship with the speculation or the speculative activity, in the terms that I think that law has a fact that is that it's always late, like the text, the practice of the law and everything is always late, because it's always adjusting to the infinitive possibilities that the human freedom has to behave wrong or right. And because of that, it's always late. It's going to be always to the second time that some phenomena happens that is going to apply the law, but not to the first one, no? But at the same time, I think it's interesting that the speculative activity is already like a kind of anticipation. It's a kind of activity of anticipation of the law, which it also has kind of limits related to this infinity freedom of the human being as kind of being that actually can do and things that we cannot even imagine right now. But it's actually a kind of an anticipative kind of movement, and I think that's pretty interesting. And it's interesting because it also steps back and can consider and reconsider the history of itself. So because of that, I was thinking, I've been like pretty interested for a couple of years now in the relationship between death and law, not in the Foucaultian and Foucault way, like biopolitics or necropolitics even, but the kind of essential relationship between law and death as a kind of fear of death that has the law. Not this, it was not like that. I think in Greek law, or for example, in the 12th of the 12th table. How do you say in English? The law of 12 tables, yeah. In which the actually public law, it was related to how we have to bury our dead relatives, and that's pretty interesting. But I think at some point, I don't know if it happens in modernity or something like that, death begins to be something that tends to be repulsed by law. And also, I think it happens with the concept of self-determination, not only related to the trans people, for example, but also and overall over the territories, this right of self-determination of the territories. Because I don't know if what do you think about this, but it's like I feel that law it's kind of engaged or kind of safe because of the concept of life and the a kind of determination that comes from outside, because it's what ensures the maintaining or the I don't know, to keep the law alive as a thing that, if we imagine a world without law, everybody's gonna be dead or something like that. And in the other hand, we have the fear of the self-determination, because if we can self-determinate everything, this is going to be like something pretty crazy, and I don't know. So I don't know how do you consider this kind of two concepts, death and self-determination, related to this kind of repulsion that law may have to them?
Well, thanks. Thank you so much. Yeah, well, the first thing that I would like to answer, the first part of what you said. I think I would present things slightly differently, and I would say that rules are always late. So the legal is always late, but precisely because of this speculative / operation dimension of the juridical, it is at the same time always, law in general is at the same time always late on the side of normativity, but always in advance on the side of the operations. And as a matter of fact, we live in a world that has been somehow created by the existence of the multiplication of beings that would not exist without law. Again, I mentioned the state, I mentioned moral persons, and there are plenty of those beings that were absolutely created by law. And to some extent, we live in a world of, if we were kind of stubborn realists, we would have to acknowledge the fact that we live in a world of science fiction, and this world of science fiction is indeed the world of law, and it's a world in which precisely the dead have a part, a huge part of what the Romans the Romans invested efforts in was precisely what do you do with the dead when the fact that someone dies creates a legal problem. I always give this example because it's an example that is so massive, but the example of the Roman citizen who dies in captivity, a soldier goes, is kept captive and dies, but he left at home his fiancée, is not married, his fiancée, and he has been doing things with his fiancée, and she's pregnant. What do you do? For the Romans, this is terrible, because when you're a soldier in captivity, automatically you lose every advantage attached to your citizenship, because a citizen by definition is a citizen only if he is free. when you're free, by definition, you cannot be a citizen anymore. You're, by definition, you belong to another realm, which is the realm of slaves. So what do you do? Because it means that this person who was a citizen, who was a patrimonium, who was in a situation, you know, but was not married, how do you make so that eventually the child that is expected, who is expected, somehow can be related to this person who is not a person anymore, according to a certain state of normativity? Well, then you have to invent this weird fiction according to which actually, you know, the womb of the woman is actually, when they had sexual intercourse, actually the womb of the woman became an extension of the body of the man himself, in such a way that the relationship, you know, the transmission of the patrimonium from the father to the son actually had already happened before the son was even born. So it means that the person who dies in this situation suddenly resurrects, but retroactively, in order for the goods, his patrimonium, his things, to actually, you know, go down, and then also the name, despite the fact that it violates blatantly one of the most sacred principles of Roman society. So this kind of science fiction still exists today. You can marry a dead people, or dead people can marry someone else. You can have in some circumstances, you know, contractual relationship with dead people, but you know that better than I do. So what I would say here is that I do agree with you fully on this kind of, on the whole dimension of law is late. I also fully agree with this kind of repression of death in contemporary normative culture, because of the fact that, you know, we are not the owner of our lives, and it's the state who owns our lives. You know, legally speaking, it's in French, it's called the indisponibilité du corps. You know, the rule of the non-disponibility of the body. You are not the owner of your body; the state is. That's why the state can intervene in your body and say, no, you cannot abort. Oh, no, you cannot change gender or sex, and so on and so forth. Oh, yes, perhaps you can, and so on. So we are not the owner of our body. So it means that life indeed is the big obsession. And because it's the big obsession, death becomes the thing that we don't want, because, you know, somebody dead is not very interesting, you know. But still, there's this remnants of a past where suddenly some people, ancient Rome or wherever, decided that perhaps the dead have a role and that could play a role within a community, and we have not erased that completely. So there's some kind of a balance. I don't know if it's any helpful to what you're doing, but that's how I would reformulate the things. If you agree with that.
Yeah, thank you very much. Yeah, it's because this obsession of life, it's kind of what causes this kind of power games or power structures in which the proper state, the status itself, is the one who creates death around it, so around itself. So that's what it's kind of paradoxical of the law. This obsession of life creates death around it. So yeah, thank you very much.
So Favor?
Hello. Camera is on. Yes. Hi. Hello, everybody. So my hair is rough. I really enjoyed your presentation. Well, because in my research, which has changed a lot, I am currently exploring avatars. I'm looking at the regulation of avatars. So I thought I was looking at the regulation of avatars at first, but over the past few weeks, I've been reading about Eugene Ehrlich, for instance, and living law, and legal consciousness and legal pluralism. And I think that what I want to do, what I'm interested in, is exploring how avatars, digital representations of people, are law. That is, I'm interested in investigating the idea of avatars as law, or law as avatars, so avatar law essentially. And what I really, I guess what I like what struck me the most about your presentation was when you spoke about well, I think there was just this idea of jurisogenesis, right? Like what Robert Cover wrote about in his article, that different communities and communities, not just in the sense of like geographical locations, but also people who, religious communities as well, for instance, create law in their everyday practices. And what I thought was very interesting about that article was where he said that the role of judges is necessarily jurisopathic. So judges kill laws in order to ensure that there is a sort of balance between to ensure that there's a balance between, well, I suppose the ground norm, the constitution, and the many minor laws that exist within a community. But I suppose one struggle I have currently, which is I think related to what you talk about regarding normativity or well, the nature of law, is I suppose I'm struggling to articulate, well, articulate exactly, well, not the articulation per se, it's the I think what I am struggling to identify is how to say that it is possible to discover or uncover the nature of law without making reference to, say, official laws or well, laws as they exist within the books, for instance. And I was wondering what you thought about that. Well, I know that for instance, usually, typically, and whenever I speak with other law PhD students or even other legal researchers, I feel that there is the expectation that if you are doing this sort of research, you need to make reference to a particular statute or one or more statutes, and then sort of explain what the deficiency is within it, and then say how your own research resolves this deficiency. But I don't want to do that per se. I want to, I suppose my vision is that I want to present something perhaps anthropological about the design and about how designers and users construct avatars, how they represent themselves, and present a notion that these practices constitutes well, law for this community. So that's my first question. I also wanted to ask what you thought about, well, I've been having this back and forth conversation with Jose about well, I know the theme of this topic is post-critical legal theory, of this conversation is post-critical legal theory. But I've been thinking about the notion of, I don't know, critical speculation, for instance, because I feel that if you when something sort of transmutes from the realm of speculation into well, reality, in terms of the fact that you're able to articulate it, then I feel that some sort of transformation has occurred, such that that thing is no longer merely speculative. It is now concrete, even if it's just in words. And I feel that the ability to fashion an idea, to pull it out of I don't know, the metaphysical, or the idea of from a notion into an idea that has been expressed, is itself the function or the result of several cultural and I don't know, historical, I don't know, factors. And so that would mean that such a thing is itself flawed by that very means. And so wouldn't that then mean that that thing is itself I don't know, frameable, and therefore then I don't know, worth some sort of a critique, I suppose, examination, description? And I wondered what you thought about that idea as well. Those are my questions. Thank you.
Well, thanks. Thanks a lot. I don't know if I'm fully equipped to answer to the second question. Perhaps they would be more equipped. My answer, my personal answer would be that, but it's purely methodological answer, so it's very disappointing. Would be that since speculation is about what ifs, critique can be, the agent of some forms of what ifs as well. I mean, it's about including, it's Giambattista Vico who in the 17th century already attacked critique in the name of what he called, topica at the time, so the abundance of truths. And he said at some point very cleverly that it was not about destroying critique, or what he called critica at the time, which was basically Cartesianism, but said that it was about trying to use, to replace it within the possibility of saying plenty, So one thing that you can add to the other. So that would be the trick, the kind of false smart ass trick with which I would try to manage your second question. But as for the first one, I mean, I'm on your page. I mean, what we need now is really that. We need to start writing about law without not even a single mention to any form of official text, judgment, document, discussion. We don't need that to be able to speak about law. And the fact that we always are forced to go back to this forces us to precisely, or makes it all the more impossible to look at the structures that are at stake, and then look at the operations that are working, and then obviously at the type of possibility that we could invent out of these operations. So I'm along with your concern of trying to devise methods in order to speak about legal realities, even if they are ghosts, but that law is, for law, it's easy to deal with ghosts. Law has no ontological problems. The law, at least the juridical operations, have no ontological problems. They can accept anything. In Muslim law, there are fantastic provisions about marriage between human beings and jinni, and everybody's fine with that. And we should be fine with that. Why wouldn't we be fine with that? Western lawyers are not fine with that. Stupid them, and sad with them. So yeah, I would go along your way, but it's an open kind of an open chantier, an open field to invent new forms of descriptions, new forms of rendering that manifest and palpable. How then the normative involves itself into constructions such as Avatar. But I would say, if I have a piece of advice, I wouldn't dare to have a piece of advice. If I had one, I would say, go ahead and fuck your supervisors or whomever you are working with, and don't mention even one piece of legislation, and then kill them in the moment when when they come and complain about it. And perhaps on the second part of the question, perhaps this again, I don't know. I don't want to force you into the discussion, perhaps you know more about it than me.
I mean, we did talk about it a little bit on Twitter inbox about that before, but I'm not sure. I guess I'm just going to give the word to Philippe again.
You sure, Zay? I mean, you organized this, so I think we're coming close to the end. So if you want to ask, I wouldn't mind. I've prepared my question to be as I can, but also I'm happy to.
Well, yeah, I mean, I think, yeah, I mean, I do get a bit like confused about the idea of critical speculation or speculative critique, because I do see those two things as contrasting in a way, and I think that is a contrast that is productive, not because I want to end critical legal theory, as Laurent also mentioned at the beginning, but because I think it sort of revitalizes critical legal theory as a field to have this internal little tension between critique and speculation. One thing that I was thinking about, and this was why I had raised my hand, is has to do with this in a way. I was thinking about, I mean, I've been reading a lot of Kelson's book, Society and Nature, which is non-legal. It's supposed to be sociological, but it's also a big revision of anthropological literature. And he mentions magic there a lot of times. And it's always negatively, because it's a very evolutionary idea of the history of humanity that he transmits there. Like the whole book is preparing what is going to present in the part of the second edition of Pure Theory of Law, where he defines the science of law as a science. And this is based on this difference between the principle of causality and the principle of imputation. And this has a lot to do with the separation of contingency and necessity, I think. You know, the world of nature, which is determined by human knowledge, because Kelsen is being here hypercritical. He's being, like, his whole effort is to make legal theory more Kantian and more critical than Kant himself or any other Kantian would have been able to do it before. So I think it's very paradigmatic of a kind of a maximum of criticism in legal theory, not in the sense of critical legal theory as, you know, critique of law as a power structure. Quite on the contrary, he is consolidating and formalizing to the maximum this infrastructure of law itself as a critical enterprise. And that whole thing is very much based on the purely epistemologicizing separation between the knowledge of nature as the domain of causality and of necessity, and the knowledge of norms as the domain of freedom and of contingency, therefore. But he speaks of magic precisely as the kind of attitude that you would have when what he calls primitive animists lived only with the principle of imputation. They didn't have the principle of causality. They only had the principle of imputation. So they lived in a world that was made of people. Everything was people, or at least potentially people. And then he says stuff like so-called magic consists mainly in the fact that the last man technically the last man technically dominates nature, the more he turns with his wishes expressed in a peculiar sign language to superhuman beings. So magic in a way would be an attitude in relation to nature that appears when you don't have a separation between validity as the mode of existence of legal norms and efficacy as something that doesn't exactly express the mode of existence of law, but that is at the same time a condition for modern law to have its particular power of creating the world of human freedom as sort of detached from this world of natural causality. So, and this whole thing is constructed through this as if also. So it is very much critical, and it's very much anti-metaphysical, but at the same time, one of the interpretations that Kelsen establishes for his ground norm, which is the foundation of mode of knowledge of law as validity, is based on Hans Weihinger's philosophy of as if. So it is hypothetical, it is fictional, right? So it is a fiction that produces this whole efficacy, and therefore in a way it does produce a kind of necessity, this kind of a magical necessity, but at the same time it negates that this is magic through this separation of imputation and causality, of normativity and factuality, of personal freedom and natural causal chains, right? So yeah, I just a question, but it's something that I just wanted to throw in there to see what you thought about it, I guess.
No, that's great. I had completely overlooked this whole his whole take on magic, but it obviously it reminds me of this section of the Heinrich Lehrer about precisely the order, the question of order and nature, where he comes, you know, at the end he comes up with this idea of of peace as the ideal to which the international order has to aspire, and an ideal that only a form of international law, that is a form of legalization of the international legal order, could help in building up. And it's funny that indeed in Kelsen, but that's a very Derridean reading that one couldn't make of Kelsen. There always are these stories that appear, bits of stories, dry little stories that eventually, I wouldn't say tell the truth, but they constitute a symptom of something which is at stake within the very dry formalization that he's trying to build, and the dry oppositions and the dry distinctions that is trying to make. And in this case, in the case that you've described, the causality imputation, I would say, but perhaps it's a bit risque as an interpretation, but I would say that basically what was at stake here is the thing that he speaks about precisely in the Heinrichslehre, in this section of order and nature, and this section about peace, which is about the story about vendetta and suddenly modernity, right? So there's this, a little bit like the primitives he spoke about in the book you mentioned. There's also here a tiny bit of a story, which is not his story, but a story that he reuses, and it's a story that goes back a long way, to Plato, and then to the Corpus Juris Civilis. There's a small Ulpian, a small a fragment of Ulpian telling the same story about before law there was vendetta. Now, because there is law, there is peace, and because there is peace, we can have peace of a higher level, so to speak. And it's absurd. It has no sense. And it's the same with the distinction that you mentioned. It has no fucking sense. There's imputation, causality. Where do you take that? From which ass do you it's literally some kind of typical modern narrative that's based on simply wishful thinking, as if science was that, and as if superstition, to put it like this, was something very distinct.
He says it's an immediate given of our knowledge. Like, we do know things as either an is or an ought, and that's it. Like, you can't question that. It's just like a given.
Yeah, this doesn't make any fucking sense. And it's simply it's a narrative, and then it's also a fiction. And he believes indeed in the power of fiction. So there is this kind of speculative dimension. Simply, it's a so sad speculation. It's a speculation on nothing that brings us back to it's there. But we know the biographical reasons, and I know it's bad to conflate biography with theory and so on and so forth. I don't care. We know why he needed that. It was a lifetime need for him to try and save law from the context in which he saw law being perverted to a level perhaps never reached, and we can understand that. And this kind of abreaction to it, and trying to, and it would buy any historian, because he was so clever, and he could come up with fantastic distinction and very elaborate things that are remarkable in themselves. But the stories always reveal the pot au rose, as they say in French. What he wants, actually, he just wanted a world where fascism was not possible anymore. and fine, but so naive stories about magic, primitivism, peace, and vendetta, and then so huge cathedrals. The contrast is it puts tears of blood in your eyes. Well, at least that's perhaps I'm disrespectful to the great Kelsen, but I don't.
So Felipe,
if I have time, thank you. I'm going to start my question.
We started 10 minutes after the beginning, right? So at least 10 more minutes.
Nice. I'll start just building a little bit on the discussion on the law and death. But really, the question is about the cultural aspects, and how, in particular, how notions of property, how they can affect our notion of the legal operations. So the first example is this. I went recently to Ghent, and the City Council of Ghent, you probably know it. It's this really interesting building, big building that is divided in two huge halves. And one half was about the urban laws and policing, and the other half was only about inheritance and filiation. And at first I was a bit surprised when I saw this, but then I realized that this kind of shows how, a large commercial city pays actually a huge attention to death, but in a very kind of commodified way. Because of course you had many rich merchants dying, and either, their inheritance or their children, the filiation was like huge problematic issue, lots of assets involved. So they had a whole half of the whole city council involved in this, right? I think this kind of points to the cultural impact of our notions of property, even for instance with death. And so this brings me to my second example, which was actually going to be my first example. And it came from my explorations of sort of Roman law a little bit, and actually ancient Irish law. I don't know if you're familiar with this, but this is a really, really interesting topic, ancient Irish law. Because it's a rare example of a legal system that didn't follow the Roman matrix, right? It's before the Roman matrix, but it's in Europe. But so we have a little bit of leftover vestiges of what this ancient Irish law was like, which we don't have for the Nordic laws, for instance. We only have the post-Christian stuff, which of course is then Roman again. So in the Roman concept of law, it was geared to artisans. I'm a potter, I buy clay. There's an exchange between the raw material entering my sphere and my money leaving my sphere of influence. Then I put effort into this clay, and then I will sell the pottery and I will get extra money back, right? There's all these, and all of this is very commodified. Is the notion of property is very much tied to very concrete commodities as artifacts. But in the example of Irish law, I think it reflects what might be an older notion of law. An older notion of property, which I think is agricultural. So the example is, the main example they give is the beekeeping law. Apparently it's one of the examples that has been preserved over time. And the way this beekeeping law works is if you put a beehive on your land, you need to give honey to your neighbors for the first 5 years, because your bees are using your neighbor's flowers to make the honey. But after 5 years, you can either keep giving them honey, or you can give your neighbors bees. And if you give them bees, then their bees will use your flowers, your bees will use their flowers, and it's kind of balanced. But it's not just balanced. I think what's interesting about this is kind of a generative notion of property. It assumes that if nature is well managed, it will fructify and it will multiply. So it's a very different cultural matrix from the Roman notion, right? So actually, again, this ancient Irish law, I think, raises really many, many interesting questions. I really recommend everybody to take a look at stuff there is online. And including, again, on my first question, it was a system of oral law. So the law was not written. And so this kind of crisis moment of the decision division is actually much more decentralized. And so there's a very different relation to power. And actually, it feels like it's quite market-led. And how meaning is made and how power is negotiated is much more market-led than these other notions that are more state-centric, that are more centralized. Okay, so my question is, thinking about the legal operations you've identified, they never directly mention property. Or if they do, they assume a certain notion of property, which is the Roman notion of property. So the question is how this kind of cultural analysis of legal concepts can impact our notions of legal operations, and whether perhaps even this could be a sense in which the critical cultural analysis can serve as a bridge to an understanding of legal operations, which I think was mentioned, this critical speculation, speculative criticism. Do you think that this actually closes the circle too much, or could it still be empowering?
Well, I think it is what we are to be doing. I mean, literally. I mean, I think you're perfectly right. I mean, the dark corner of Roman law is the fact that it is only about property. It's never, persons. When you look at it, carefully and technically, everything that concerns persons is secondary. It's literally law made only for that, only for how do you make goods circulate, how do you transmit them, and then you need marriage for that, and then you need testament and contracts, and you need, so basically it's only that. And one could go as far as to say that a legal subject, persons entered law as legal subject only as function of the transmission of patrimonium. So it's it's the terrible truth about the context in which the Roman inventions were created. So indeed, I'm all in favor of kind of comparative cultural analysis. As a matter of fact, I dedicated one book to that. I'm doing some commercial. It's late, so it's time for commercial. So this book, which is called After Law, which is actually a book which is about before law, before Roman law, before Greek law, all these other systems, ancient Egyptian law, Mesopotamian law, but also non-Western legal system, Chinese, Hindu, but also Jewish law, Islamic law, and so on and so forth. All the untapped possibilities that could be used within the European legal system as exploratory tools or speculative operations that has not been. For instance, the question of contradiction in Jewish law. Jewish law has no problem with contradiction. You can have at the same time, for the same set of facts, completely contradicting solutions coexisting, and it's not a problem, because the issue is not the consistency of the order, but the tradition that you can trace in one direction or another. Or, for instance, the ontological generosity of Muslim law compared to Western law. I mentioned the genie issue because it's the most massive one. And then you have all other options like that. So I'm fascinated by your example in ancient Irish law. I will look for it. I love that. I think we need that, and we need that in order to show that this Western construction, as extraordinary as it may seem, and this fantastic potentiality is still active within the juridical dimension of operations within this Western legal system. It's not all that there is to it, and we definitely need to inspire ourselves with lots of other things, if only just to get rid of the Eurocentric, Occidentalist, blah blah blah, point of view. But I think that it can also work within the tradition itself. And I have this example of this French lawyer, Sarah Van Uxem, who wrote this very nice book on the ownership of the land, of the earth, where she actually says that we have misunderstood one key aspect of the Roman understanding of property, and which is the fact that because Roman law was a form of law based on things, actually the property, the ownership of things, didn't belong to subject, but to the things themselves, as having persons taking care of them that we call legal subjects. So actually the relationship of property is not subject owning things and having things and then being able to do whatever he or she wants to do with it, but the other way around. The object giving to a subject the capacity to do something, including its own destruction in certain circumstances. And that is, I love that. That is a brilliant reading, a brilliant reversal of the understanding that we have of property. So we have to, in my opinion, we have to do both. First, expand the cultural landscape at our disposal and stop being, purely, Roman. But at the same time, reread more carefully the Roman tradition itself, because it's also a tradition that is full of traps and false ways, and we have our memory goes only in the direction that we're interested in, and that there are lots of things that we've missed there, and so the narrative here has also to be reshuffled. So yeah, thanks for the great example.
Thanks.
Thanks. So should we wrap it up?
My ass hurts a little bit, to be fair.
Sorry?
No, I said my ass hurts a little bit. I've been sitting down 2 hours.
Yeah. We've been sitting down for 2 hours. I think it's a good time. So I'm going to end the recording. So thanks for everyone who has, we can say a little bit after I end the recording just to say bye, but thanks everyone who has been here, and for everyone watching on YouTube. And we are probably going to have our next session with Swasti, who is here with us, presenting on her work on object-oriented ontology and law. It's probably going to be the 23rd of this of next month of May, in the same time. We're going to confirm that through the email. But yeah, so finishing the recording.